Good morning, everybody. First of all, 10 o'clock this evening. Looking forward to welcoming Mill Billy back in order to do a chat where hopefully we'll have some no sound issues. Really looking forward to chatting with Mill Billy. That's 10 o'clock UK time. So just in 10 hours and 20 minutes time, and that'll be 4 o'clock for Millbilly Central time. So that's tonight for me here in the UK. Interestingly, how somebody, a well-known commenter, DB Cooper, got in touch via Twitter email and said, when are you going to carry on doing your look at the appeals process? I believe the last time I did a video with part 9 was obviously back in July, and then of course we had a disaster with Ericose, but it was always my intention to get back and look at this this particular aspect of the appeals process for Brendan Dassey. This is looking at the en banc decision. The majority decision, of course, was written by that awful creature, Judge Hamilton. But I would just like to point out that in the part 9, we get a comment from a particularly notorious character who has continually refused to accept my invitation to come on and do a live chat and put forward their opinions. And to this person, yeah, you can stick your tongue out all you like. You'll probably be sticking your tongue out a lot more, actually, because apart from the comments left on the part 9 video, everything else that person has posted since, commented since, has been deleted and will be deleted until I see a message or a comment that says, I would like to accept your invitation to do a respectful live discussion. I have invited this character on multiple times, explained that we are very respectful. Certainly, this character engages in trying to provoke people by personal insults or attempts at personal insults, all of which are completely laughable. As I've always pointed out, the dude and I used to share far better insults than this particular character has ever done. So once again, to this character, I think most of you know who I'm referring to. Comes on, makes a lot of noise, writes a whole load of paragraph of nothing. Your comments, as I say, they are being deleted. You have been invited on multiple occasions to come and discuss, and all you do is you post comments and, as I say, engage in trying to provoke a response by making personal attacks. And as I say, it's not going to happen anymore. All of your comments will be deleted, but yes, you can't imagine who I mean. There is somebody did get in touch with me, suggest that the person goes by this, is the actual surname is a German sounding name such as Messerschmitt or something like that. But anyway, goes by this particular cartoon character. I'm sure most of you have come across this person who is clearly, no, I know, I think it's somebody that's very much involved in Manitowoc law enforcement. Wouldn't surprise me at all. Anyway, makes it quite clear their hatred of the Avery family. So anyway, let's have a look at what I was saying that wanted to look at. As I say, final message to the cartoon character. Your messages, your comments will be deleted if I see them. If anybody sees them, please let me know. I actually don't get any notifications of who has commented anymore. I don't know why that is. If I've clicked on a wrong button or something, but I don't actually get notifications of people making comments anymore. I only get notifications. I wonder if it's because I'm subscribed to so many channels that I only get notifications of when a new video has come out. As I said, final comment to the cartoon character. I've been respectful to you. I've been, invited you on numerous occasions to come and do a live chat. I've offered you the fact that, as some people do when they join in the live chats and they wish to remain anonymous, they can just have a blank screen with a picture. They can stop their camera, and so that we just hear them. But as I've warned this cartoon character many a time, be prepared to answer some very serious questions. Anyway, as I say, I've never yet had I'm not even going to call them a guilter, just they're haters. I've never yet had a guilter or a hater accept any invitation to come on and actually debate sensibly, respectfully, the situation. So, right, Sharon, yes, there probably is a new setting because I've had a few updates, so maybe that's what it is. Anyway, moving on. So what I probably need to do first of all is just do a quick recap of where we were up to within part 9. And, I would start by pointing out that, let me just turn that off just for a moment. In looking at this case, very important, 20 months ago in Edinburgh, I went to see Steve Drizzen and Laura Nyrider at the Queen's Hall as I say, in Edinburgh. It was great. I got there early, parked just a bit further on down the road where there was no restrictions. And actually, as I was looking out the car window, sort of waiting for the time to tick on, who should come walking up the road but Steve and Laura themselves. So I managed to get a quick chat with them, welcome them to Edinburgh, etc., etc. Got my photograph taken later on where I look really starstruck for obvious reasons. But it was during the presentation that Laura Nyrider pointed out, much to the, if you like, the surprise and the alarm of everybody assembled, was the fact that when Brendan Dassey and when Steve and Laura, when they won the original 7th Circuit hearing, and they won it 2-1, as Laura said, we had won, but we had immediately lost. The reason they had immediately lost was because one judge, Judge Hamilton, had dissented. And the way, of course, that the EDPA works is that habeas corpus relief is only granted in the most egregious cases where it's decided that, with Duffing having decided in Brendan's favour, that no other judge in the country would see it differently. And of course, Judge Hamilton decided that he did want to see it differently. And dissented. And of course, that then created the 7th Circus en banc hearing, which is where we started off. We were just a few paragraphs into Judge Hamilton's majority opinion. And so let's first of all go back and have a look at what Judge Hamilton had written. And what had particularly annoyed me, got me most angry, was this. Let me just make sure everything's working as it should do. Let's just move that across a bit. Yeah, everything seems to be working fine. Okay, let's hide that. So, as I say, this is the decision. Let's do it this way. It moves a bit easier. It argued September 26, 2017, decided December the 8th, 2017, before, obviously, Wood, Chief Judge, Easterbrook, Khan, Rovner, Williams, Sykes, and Hamilton. And it's Hamilton, of course, that writes the majority decision. And if we come down to, I don't think it's very, very far down that I need to go to find this this particular bit. Yes, okay. Let's just go from this paragraph here. As a result, federal habeas relief from state convictions is rare. It is reserved for those relatively uncommon cases in which state courts veer well outside the channels of reasonable decision-making about federal constitutional claims. EDPA deference is not conclusive, however. Where the record shows that the state courts have strayed from clearly established federal law, we can and do grant relief. And it was the we bit of it. And I wanted to find out in the cases that are quoted here, so for example, Richardson versus Griffin, was Judge Hamilton actually involved in that decision? No, he isn't. He is not. Did he look at that? No. Jones versus Callaway? No. So that was back in 2017. This is back in 2016. McManus versus Neal back in 2015. Did Hamilton have anything to do with that decision? No. We have to go back to 2013 to Shaw versus Wilson to see when Hamilton actually was involved in the Seventh Circus granting habeas corpus relief. So let's now have a look at the next thing I want to show you, which is exactly where we got up to in this, looking at this particular case. So here we go. Here's Shaw versus Wilson, that, as it says here, was before, decided on the 24th of July 2013, and it was before Flom, Wood, and Hamilton. And if we come down to, I think if we come down to offence and trial, I think that would be a good place to start. And then we can have a look at what the situation was. That didn't catch up very well. There we go, yes. No, okay. Let's do it this way then, so we can get it to come up. Ah, that seems to be better. Okay, yeah, there we go. Offence and trial. So this is, as I say, Shaw versus Wilson. And this was a case in Indiana. Shaw was 18 years old and had just finished high school at the time of the deadly attack that landed him in prison. Days earlier, he had been recruited to sell magazine subscriptions as part of a traveling sales team. And he arrived in Fort Wayne, Indiana, with the team on June the 5th, 2000. The trouble began when his boss, Eric Wazinski rented several motel rooms for the group, and in one of those rooms encountered and confronted Brett King, an uninvited stranger. King fled, but as he ran away from the motel, Wazinski yelled to his employers, "Get him." Two of them, Stephen Johnson and Chris Starling, obliged, chasing King down and knocking him into a ditch. Several other team members then joined Johnson and Starling in punching and kicking King. He died in the ditch from multiple blows to his head. The attackers had disbanded by the time police arrived, but Johnson, Shaw, and a third team member, Benjamin Brooks, were arrested and charged with aggravated battery. Shaw denied even being present during the fatal beating, but Johnson and Brooks admitted participating, and at some point they told authorities that Shaw had been the most aggressive of the attackers. The two negotiated sentences of 2.5 years in prison, 8-year sentences with 5.5 of those years suspended, in exchange for pleading guilty to involuntary manslaughter and agreeing to testify against Shaw. Again, we have this classic example of two of them taking the plea deal in order to secure a conviction against Shaw, who had nothing at all to do with the attack. After Johnson and Brooks cut their plea deal, the state moved to amend the information to charge Shaw with murder rather than aggravated battery. His trial lawyer objected on the basis of Indiana Code 353415, a statute that had long limited prosecutors' discretion to amend pending charges. The version of the statute then in effect specified that an amendment of substance could be made up to 30 days before the omnibus date, defined by state law as a point in time from which various deadlines are established, and an amendment of mere form could be made even later if not prejudicial. Because the precise language of the 1982 version of the statute is important to Shaw's case, we set out the relevant portions here. As I say, we've been through that previously, so let's go fast forward to where we were about to get up to. The crux of the matter was the fact that Shaw is going through his new appeal, through his appeal. He's trying to point out the ineffectiveness of counsel by the original trial lawyer not challenging this 30-day rule, and him being charged, I think it was 6 months later, as a result of this plea deal. So anyway, let's it's the next section, ineffective assistance, that we need to get to. Let's come on down to nearly there. Yeah, just after this one, I believe, is the next section. For some reason, it goes back to A. There we go. Deficient performance. Okay, this, as I say, this is exactly where I was up to at the end of part 9. So this is us carrying on, not quite 2 months later. But as I say, hopefully you're sort of catching back up to what's going on in this case. Let's have a look. Appellate, and by the way, you can find the document, this document. It's in the description of part 9. So if anybody wants to go through the whole lot again, it's there, okay? But we'll just carry on with Section A, deficient performance. Appellate lawyers are not required to present every non-frivolous claim on behalf of their clients. Such a requirement would serve to bury strong arguments in weak ones, but they are expected to select the most promising issues for review. For this reason, if Miller, that's the person obviously that Shaw is saying represented him ineffectively, abandoned a non-frivolous claim that was both obviously and clearly stronger than the claim that he actually presented, his performance was deficient unless his choice had a strategic justification. So as I say, Miller should have gone with the fact that the state law clearly makes it obvious that in charging Shaw, they had 30 days in which to amend the charges against him and raise them from aggrieved, aggravated battery to murder. They didn't. They waited until they'd had that got the plea deal in place with the other two that had been involved in the murder. They then got off with incredibly light sentences in exchange in this plea deal for pointing all the blame at Shaw. But as it says here, yes, for this reason, if Miller abandoned a non-frivolous claim that was both obviously and clearly stronger than the claim that he actually presented, his performance was deficient unless his choice had a strategic justification. This standard is difficult to meet because the comparative strength of two claims is usually a bit debatable. Yeah, not in this case. But Smith confirms that the theory is available. We evaluate Miller's performance from the perspective of a reasonable attorney at the time of Shaw's appeal, taking care to avoid the distorting effects of hindsight. We conclude that this is one of the rare cases in which counsel's performance fell below the constitutional minimum and that the Indiana Appellate Court's conclusion otherwise was an unreasonable application of Supreme Court precedent, particularly given the concession that the evidence could support either conviction or acquittal. The sufficiency argument that Miller made on Shaw's behalf was so weak that pursuing it was the equivalent of filing no brief at all. You know, as I say, we're getting a flavour of the sort of thing that is so clearly obvious that even Judge Hamilton cannot go against the state. While sufficiency challenges always place an extremely difficult burden on the defendant because the evidence is viewed in the light most favourable to the verdict, the argument Miller presented was a certain loser. We suspect this exercise in futility was effectively a substitute for an Anders brief. Because in Indiana appellate attorneys must submit an ordinary appellate brief no matter how frivolous counsel regards the claims to be. Because Miller made a single argument that any reasonable lawyer would have recognized as dead on arrival, we have a situation close to the one described in Smith versus Robbins, where counsel erroneously refrains from filing a merits bill at all. In that situation, the court held the defendant need show only that a reasonably competent attorney would have found one non-frivolous issue warranting a merits brief. The same rule should obtain if counsel raises only an where did it go? No, I think I've gone too far. I think it's jumped. Let's go back. Jumped quite a bit. This is annoying. Just never mind. We'll get there. In that situation, the court held the defendant need show only that a reasonably competent attorney would have found one non-frivolous issue warranting a merits brief, i.e. the same rule should obtain a counsel raises only an entirely frivolous argument and passes by another that is genuinely arguable under the governing law. If counsel raises only an entirely frivolous, and that's really the crux of the matter here, that the lawyer Miller did go with a completely what they term a frivolous claim when there was such an obvious problem in this case. So that a claim challenging the validity of the amended information would have been obvious at the time of Shaw's direct appeal is beyond question. Even Judge Hamilton agrees with this. Miller should have learned of the potential claim while reviewing the trial record because trial counsel carefully preserved it by objecting and, as Indiana case law requires, requesting a continuance. See Kidd versus Indiana. The trial counsel's preservation of a claim can make it obvious. See Suggs versus United States, finding challenge to improperly admitted evidence to be obvious because trial counsel had objected to the admission and described the issue in a pre-appeal brief letter. Mason versus House. This issue was an obvious one to raise on appeal is beyond dispute. Mason's lawyer had, of course, objected to the hearsay statements at trial. Considering, in addition, the language of section 3534.15 and the fact stressed by Shaw that dozens of similar, though unsuccessful, challenges were documented in, let's be very careful how far this jumps, in published opinions, Miller's abandonment of the objection to the amended information cannot be excused on the basis that the claim was obscure or novel. Nor can Miller's abandonment of that claim be excused on the basis that it would not have appeared promising enough. This is a relative inquiry, and there is no doubt that the amendment challenge had significantly more promise than the sufficiency argument. The amendment issue, far from being frivolous, had a better than fighting chance at the time of his 2002 appeal, considering the text of section 3534.15 and the 1998 statement in Hark that if the amendment was of substance, it was impermissible under the statute from 30 days before the omnibus date. Shaw also cites other cases from the Indiana Supreme Court that he says would have supported a challenge to the amended information at the time of his appeal. The most compelling among them are Wright versus Indiana and Sharp versus Indiana, which both include declarations that a charging document cannot be amended to change the identity of the offence under the deadline in section 35, 3415. Similar statements are made in appellate cases. See Taylor. The amendment here did not change the theory of the case, change the identity of offence charged, or cause prejudice to Taylor's substantial rights. Therefore, the amendment of the information in this case was not error. The state counters that the Indiana Supreme Court's reading of Section 35, 3415 in Fajardo sharply diverged from that court's prior understanding of the statute in Hague, and thus was a radical change in the law, not a clarification. But that line of argument implicitly draws us into the content of state law, and we have emphasized that this is forbidden territory. Once again, it is necessary only to conclude that the amendment issue was clearly stronger than the sufficiency argument, and we have no trouble coming to that conclusion based on both the language of the statute and the Indiana Supreme Court Hague decision. Defense attorneys, it is true, are generally not obliged to anticipate changes in the law. I wonder why. See Venezuela versus United States, Mayo versus Henderson. But in some instances, they are obliged to make an argument that is sufficiently foreshadowed in existing case law. See Thompson versus Warden. Counsel's failure to raise an issue whose resolution is clearly foreshadowed by existing decisions might constitute ineffective assistance of counsel. Quoting Lucas versus O'Day and Alaria versus Bennett, to determine whether reasonable counsel would have predicted the Antomarchi outcome and objected to the trial court's supplemental Allen charge, we must examine the extent to which prior cases foreshadowed the Antomarchi holding. In Hague, the Indiana Supreme Court did more than foreshadow Fajardo. The court explicitly stated the same rule that it later would apply in Fajardo. Although Indiana appellate courts resisted that clear statement until Fajardo was decided, see Townsend versus Indiana and Davis versus State, the fact that an intermediate court likely would have rejected the argument at the time of Shaw's appeal is no excuse not to make it. See Mayo. Attorney's omission of a meritorious claim cannot be excused simply because an intermediate appellate court would have rejected it. Arazio versus Duggar, holding that appellate counsel was obliged to raise a challenge that, although likely to be rejected by the appellate court, ultimately would have been successful in the state Supreme Court. Wow, so they are expected to play the game until it's gone all the way down the line and then overturned by the state Supreme Court. Seems a bit bizarre to me, but well, actually, it does seem bizarre, but that's exactly what Kathleen Zellner is going through, isn't it? The state also stresses that Shaw cannot point to a single published case before Fajardo in which an Indiana appellate court invalidated any amended information in reliance on the 1982 version of Section 35-3415, suggesting that Miller rightly would have viewed a challenge as a waste of time. But the state is looking at only half the picture. Sometimes they do that. As Shaw points out, it has not identified nor have we found any published case in which a change had been elevated to murder from something lesser after the statutory deadline passed, though such an amendment would be permissible if new evidence were to come to light. see Warner versus State. And this dearth should have suggested to Miller that the amendment in Shaw's case was unusual and distinguishable from those that had been upheld. Moreover, Section 353415 was not a dead letter. Some trial courts did disallow untimely amendments, and appellate courts thwarted prosecutorial attempts to get round those rulings by dropping the original charges and refiling more serious ones. Davenport versus Indiana, vacating conviction where the state had received an adverse ruling in the original trial court on its untimely motion to amend the information, and so dismissed the case and filed a second information in another court. If they don't get you the first time, we'll get you the second time. Indiana versus Klein, affirming dismissal of charges that were filed solely that's good. Affirming dismissal of charges that were filed solely to circumvent the court's previous order refusing an amendment that was untimely. Okay, by the way, this isn't Hamilton that's writing this. No, he's agreeing. He's that they agreed, the three judges, but this isn't Hamilton writing this. The bottom line is that Attorney Miller was faced with two potential arguments. One, undeniably frivolous, and the other solidly based on a state statute and reinforced by the Indiana Supreme Court's pronouncement in Hark. In the face of this choice, Miller opted for the hopeless sufficiency challenge. The record reveals no strategic reason for his choice of arguments, and in any case, no tactical reason can be assigned for his failure to raise the only substantial claim that Shaw had. C. Fagan, Smith versus Murray, concluding that appellate counsel who did not raise a claim that was questionable under Virginia law, but did raise 13 more promising claims, was not deficient. Fair-minded jurists who have the proper standard in mind can conclude only that Miller's performance fell short of what Strickland v. Washington and Smith versus Robbins require, and that the Indiana Appellate Court's conclusion to the contrary was an unreasonable application of Supreme Court precedent. Prejudice. On the question of prejudice, the Indiana Appellate Court said simply that Shaw, because he was given extra time to prepare for trial, was not prejudiced by the court's granting of the prosecution's motion to amend. But that takes too narrow a view of the matter. Strickland requires us to ask whether there is a reasonable probability that, but for Miller's unprofessional errors, the result of Shaw's direct appeal would have been different. In assessing prejudice, we must bear in mind once again that we are making a comparative inquiry about counsel's choices. We are not resolving any issue of state law, and we are not telling the Indiana judiciary how it should approach this issue. Prejudice exists, however, if counsel bypassed a non-frivolous argument that, if successful, would have resulted in the vacation of Shaw's conviction, just as the conviction in Fiado later was. If one is entitled to a dismissal, a continuance is no comfort. And when evaluating prejudice, unlike when evaluating attorney performance, hindsight is permissible. Lockwood versus Fretwell, Hemstreet versus Greener, Edmonds versus Peter. This means that the Indiana Supreme Court's ultimate decision in Fiado is relevant to whether the argument Miller jettisoned was both non-frivolous and stronger than the sufficiency argument he presented. And at this point, I suppose I'm not trying to be critical of Dean and Jerry. But of course, we do know that they were highly excited, and we saw it on film. Maybe they didn't want to be seen on film being so excited about finding the blood vial, when in fact all along Stephen Avery had been telling them that he suspected that the blood in the RAV4 had come from the sink on the Thursday night when he went out to Menards and saw lights and came back, find the blood cleaned up and the smell of cigarette, which as a non-smoker, I can assure you, you can immediately pick up on the smell of cigarette. Anyway, let's carry on. Although I suppose, yes, that might be one aspect of when Dean and Jerry do have to go to an evidentiary hearing to cover their ineffective assistance of counsel. One would imagine that's one of the items that would come up. Maybe some of you think differently, but I can't help thinking that will be mentioned. Anyway, the state posits that the amendment to the information in Shaw's case may have been one of mere form. If that were undisputedly so, then the amendment theory too would have been dead on arrival. But counsel had a strong argument that this particular amendment was substantive. After all, the amendment elevated a charge from aggravated battery to murder, thereby increasing the possible sentence more than threefold. Aggravated battery, a Class B felony, is punishable by 6 to 20 years in prison. And of course, that's what the other two got, wasn't it? It was eight years with 5.5 suspended. And 3552(3), murder, is punishable by 45 to 65 years. The state argues that in the final analysis, the state courts might have concluded otherwise, quoting the Indiana Supreme Court's comment that if the defense under the original information would be equally available after the amendment is made, and the accused evidence would be equally applicable to the information in one form as in the other, the amendment is one of form and not substance. The amendment is of substance only if it is essential to the making of a valid charge of the crime. Sharp versus State. But once again, Shaw's theory does not turn on the ultimate outcome in the state courts. It depends only on the relative strength of this argument over the one counsel chose. The argument that the amendment was substantive is not frivolous. The state Supreme Court offered its statement in Sharp in the context of an amendment that did not change the identity of the offence charged. Counsel thus could have argued that Sharp does not apply to an amendment that substitutes one offence for another. More importantly, in rejecting Shaw's post-conviction petition, neither the Indiana Appellate Court nor the trial court suggested that the amendment was not substantive. The state also touches on, but does not develop, another argument that Shaw cannot show prejudice. This one is based on the Indiana legislature's decision in 2007 to amend section 3534.15 in the wake of Fajardo. The statute now treats amendments of substance the same as amendments of form. The line of cases following Lockhart versus Fretwell and Nix versus Rightside stand for the proposition that Strickland prejudice cannot be established if counsel's deficiency was in not making a claim that, although valid at the time of trial or appeal, has since been rejected. The rationale is that defendants must not receive a windfall as a result of the application of an incorrect legal principle or a defensive strategy outside the law. But Fretwell and Nix do not foreclose a finding of prejudice in Shaw's case. A legislative repeal of a statute does not present the same situation as the one in which a court mistakenly recognizes a right for some period of time and then corrects itself or is corrected by a reviewing court. The Fifth Circuit has explained a distinction. A case that has been overruled is not authoritative in all pending and subsequent litigation, whereas a duly enacted statute confirming procedural or substantive rights entitles its beneficiaries to those rights for the period in which it is validly operating. Unlike the benefit in Fretwell, a state statute is not an error, misapprehension, or right the law simply does not recognize. Young versus Dretka. Shaw seeks relief from counsel's failure to meet the valid legal standard, and the Indiana legislature's later decision to charge that standard does not defeat Shaw's ineffectiveness claim. Fajardo itself offers some insight into what the state Supreme Court would have done in the period before the amendment. We do note a division of authority in Indiana over whether the legislator meant for the current revised version of section 3534.15 to apply retroactively. Compare Fields versus Indiana, holding that the former version of the statute and Fajardo apply on direct appeal even when the offences were committed prior to Fajardo. With Hurst versus Indiana, holding that the statute enacted in reaction to Fajardo is retroactive, though the legislator did not expressly provide for retroactive application of the amended statute. The resolution of that debate, however, is not pertinent to our case, no matter what its outcome. Fair-minded jurists must agree that Shaw has demonstrated prejudice. He had a reasonable chance of success on appeal, but for Miller's deficient performance. The state also cites a case holding that Fajardo is not retroactive in a collateral attack, Leatherwood versus Indiana, but that decision is irrelevant because the relief to which Shaw is entitled is a new direct appeal. Should Indiana choose to grant this relief instead of releasing Shaw outright, the Indiana appellate courts will be free to consider all pertinent issues of state law at that time. Because Miller's performance was deficient and Shaw suffered prejudice as a result, the decision of the district court is vacated and the case is remanded with instructions to issue a writ of habeas corpus unless the state of Indiana grants Shaw a new appeal within 128 days after issuance of the mandate. And as I say, that was written by Judge Wood, who we've come across before. So going back to, as I say, this paragraph here, where it refers to the we can and do grant relief. As I say, that's the only one, Shaw and Wilson, that I've come across where Hamilton, the most recent, I think in Harrison and Thompson and possibly Jones and Basinger, which go back to 12 and 11, there is possibly a involvement by Hamilton in looking at that case. Let's just have a look then. Let's consider the final bit of this paragraph. Review of state court factual findings under EDPA is similarly deferential. Under 2254, federal courts cannot declare state court factual determinations unreasonably merely because we would have reached a different conclusion in the first instance. 2277, 2015. Internal quotation marks and citation omitted. EDPA does not permit federal courts to supersede the trial court's determination if a review of the record shows only that reasonable minds might disagree about the finding in question. Well, Hamilton, I would suggest that yours is definitely an unreasonable mind and certainly not a reasonable mind. But again, deference does not imply abandonment or abdication of judicial review. I like that word abdication because that's exactly what you did, and does not by definition preclude relief. Okay, I think we'll stop there, and then I'll mark down we're at B, the law of confessions. And of course, one of the things that we do get to look forward to later on in this majority opinion by Hamilton is his version of the control question, which is, I thought one of the nice words that we heard today was frivolous. Yes, that's how I would describe Hamilton's assessment of the control question, frivolous. Anyway, the law on confessions. Okay, let's let's hold it there. Let's come back to that. Woody, as I say, if you want to come and make comment, well, you're going to have to, as I say, just a simple, I accept your invitation to come on and to respectfully debate the Stephen Avery, Brendan Dassey case without the need to try and provoke animosity by personal attacks. I suspect that you are completely incapable of that because, as I have pointed out many a time, this picture, you see that yellow there and there and there, it should be all over. You're a complete coward, having no possibility, I don't think, of ever not being a coward. Anyway, we'll catch you all soon. Yes, I can do that because, yes, done. Sharon, happy to. Paul, can we please give Rhonda South, just Rhonda on YouTube, a wee shout out as she did her first show last night? And Richard? Oh, you mean the dude? Yes, I would be so proud. Rhonda's show is available there, and I did see mention of it. Yes, I did see mention of that. So yes, most definitely. The more people on the train, the better. The more people, as Putin famously said, shining a light on the vampires that like to hide in the darkness behind their misdeeds. The more we can do that, the better. Anyway, that's let's say all I've got time for this moment in the day. But as I say, I am looking forward to catching up with Mr. Billy later on tonight in 9.5 hours time. So, well, yeah. We do know what happened to KK. Yes, he's moved to Adelaide so that he can be next to Dr. Silkman. I don't think, but he certainly reappeared on Twitter as this so-called expert in crime scene analysis, claiming that the item FL managed to migrate onto the pile of dust as a result of the jackhammering. Yeah. No explanation as to how the wood got in there. No, a complete farce. But we do know, yes, that he did sell his house in Appleton for, unfortunately for him, far less than he thought it was worth when he was sexting his first victim. It certainly wasn't the same price it sold. In fact, when you think it's nearly 10 years later, and to have lost value, one suspects he probably wanted to get out pretty quickly. And rumor has it that he has gone to LA or Southern California, should I say. Okay, we'll catch you all later, and as I say, we'll carry on with that item B, the law on confessions, and hopefully get at some point. Have you seen him yet? Have you seen him? I don't think so. I don't think you've seen him at all. Okay, we'll catch you all later. Thanks for joining. Bye for now.